to Ian Burton, who is the chairperson of the Training and Development Committee. Now, he sits on various committees within the board, but in particular, he is the chairperson, my chairperson of the portfolio that I handle, which is training and development. And Mr. Burton, as you know, has been in the profession for a very, very long time, way longer than me. And I've been around. In November, I'll be here for 22 years. He has been here, I think, for 44, right? Is that correct? Good morning and welcome, Mr. Burton.
Good morning, Mr. Nell. Thank you very much. Good morning, everybody. Allow me to just welcome you guys to the session this morning that Mrs. Finnigan is going to facilitate for us. But most of all, colleagues, admin staff, deputies, members of the board, staff members of the board, welcome. But before we proceed, I just want to take this moment to introduce you to our chairperson of the board, Mr. Mark Morgan. If Mr. Morgan is available at this moment, if I can just introduce him to you, and he would like just to join us in a word of welcome. Thank you.
It is over to you, Chairperson Morgan.
Thank you very much, colleagues. Good morning, Mr. Burton, board member and chairperson of the Training and Development Committee. Just, sorry, colleagues, I see I can't switch on my video. I don't know for what reason. It says you cannot start your video because the host has stopped it. Not sure, Mr. Nell, can you sort that out? Or is it fine if I speak off camera?
Lucinda will sort it out for you right now, sir. Please go ahead.
Okay, there we go. Thank you. Can everyone see me?
Correct, sir.
Okay. Thank you very much. Thank you. So yeah, good morning and welcome to everyone to all the sheriffs that are joining us today. Special warm word of welcome to the facilitator, Ms. Finnigan, who's gladly agreed to assist us with provide us today's session with ease. So thank you very much, Ms. Finnigan. Sheriff colleagues, fellow board members and colleagues who sit on the board, staff and officials, good morning. Without further ado, I would really like to thank the organizing team from the South African Board for Sheriffs that have made this event possible, or this training event possible, to get all the participants, or most of the sheriffs, abreast with the requirements of the Protection of Personal Information Act, or the POPIA Act, POPIA Act, as we all know. This is a very important piece of legislation in our country because it gives effect to the rights and values entrenched in Section 14 of our Constitution, which in brief provides that everyone has the right to privacy, including the right to protection against unlawful collection, retention, dissemination, and the use of one's personal information. I think this is a very, very important piece of legislation as it came at the backdrop of a lot of companies or communications companies exploiting rather, or in fact, infringing that right towards of most South Africans when it came in terms of telemarketing and all those unfair and unwanted commercial practices, which do not echo well or in line with the fundamental values and principles enshrined in the Constitution. So this is an act that I think all sheriffs need to abide or adhere to closely. The one problem that we have in the profession and across board is that there are so many pieces of legislation that they remain applicable to our practices as sheriffs. However, because of the voluminous nature thereof, not all sheriffs are able to comply fully with them. One would really stress and emphasize that we do our best in adhering to all pieces of legislation that are enacted in the country, because although the board is not directly the custodian of ensuring compliance, regulatory compliance with these pieces of legislations, but those authoritative bodies, if they then find you non-compliant in one way or another, and then the matter lands up on the board's desk or complaints department, legal department, it may possibly hinder on your practice as a sheriff, because it will then overlap with the right of the South African Board for Sheriffs to keep a good reputation and esteem by that particular office bringing the South African Board for Sheriffs or the office of a sheriff into disrepute. That is where we would really, or our jurisdiction would then be invoked after a complaint has been lodged by whichever authoritative body, be it SARS, be it the information regulator, or any other authoritative body that is tasked with ensuring that all our practices or entities, whether private or public, adhere to the laws of the country. So it's very important that sheriffs do attend these training sessions so as to get better knowledge. And once again, so that when they come, or it happens in the fortunate event that such similar complaint is laid, was put before us, they cannot plead ignorance of the law. Because as we all know, ignorance is not an excuse at all. So colleagues, without further ado, thank you very much for all those who participated, who took their time to participate in this event or in this training session. I am sure that it will come in handy for most and all of us, and I'm almost certain that the 50 odd number, in fact we're 71 participants now, say the 60 something odd participants that are here will indeed benefit from the session, sorry. And I do hope that they will remain compliant. And these are sheriffs that I will not be encountering their matters when it comes to our disciplinary and complaints department matters. So thank you very much, Program Director. Thank you, Mr. Burton, for ensuring that under your auspices this event gets to happen. Thank you very much, Mr. Nell, for directing and guiding the training and development team to ensure that this happened. And thank you very much to the facilitator as well, who is assisting us in this, in ensuring that today's training session is a success. But let's not also forget the sheriffs, whom we are making this, or whom we intend this session is for. So thank you, sheriffs, deputies, office staff, and all those who are in attendance. I thank you.
Advocate Morgan, thank you very much. Thank you for the welcome. I must say I'm honored to have you with us this morning, and I truly hope that you will enjoy the session as much as we are looking forward to it. Without further ado, let me take this moment to introduce you to Ms. Jennifer Finnigan. She's a partner in a firm called Chairperson & Wiley, Durban, also offices in Joburg. I'm going to read her bio to you because I'm not going to remember half of what was sent to me. So allow me just to share some information, not too personal, but some information of her. I'm going to read it as it was given to me. Jennifer is a commercial compliance and competition lawyer. She has assisted local and multinational clients with compliant investigations by the competition authorities, regulatory deals with merging filings, and advises on antitrust compliance issues. She's experienced in negotiating and drafting a wide range of contracts and has extensive specialist experience in the ports sector, logistics, automotive, and sugar industry. Jennifer has dealt extensively with terminal operator licenses, leases, concessions, and tenders in the port space, both local and on other African ports. In every contract, Jennifer focuses on plain English drafting and creating user-friendly, practical contracts. Jennifer has a strong interest in financial intelligence and data privacy compliance law. She has developed compliance documents, policies, and training required in relation to the Finance Intelligence Center Act, and the Protection of Personal Information Act, and has assisted a number of clients with investigations by the Financial Intelligence Center. So it is my great pleasure to introduce to you Ms. Jenny Finnigan. She's going to be our facilitator for today. And I truly hope that this is going to be a session with a lot of information, some very good questions, and I truly hope that everybody enjoys it. Thank you very much. Ms. Finnigan.
Hi, everybody. You're all very formal, and I'm not. So I'm Jenny Finnigan, as Mr. Burton introduced me. And I just want to put us, are you getting the slides? I just want to see if you're getting the slides.
Not yet.
Not showing yet. Okay, let's go back. You know, we did practice this, believe it or not.
May I just take the opportunity whilst Jenny here will get those slides up, just to inform everybody that the request to have a better understanding of POPIA and the POPIA Act was in fact came from the profession, and we had approached her via firstly it was Mr. Singh, and then Mr. Burton, and then I, and we harassed poor Jenny and asked her for pro bono services for today. So the chairperson, Advocate Mark Morgan, had in fact formally approached her with some questions that we did get from the sheriff's profession, and then Mr. Burton and Mr. Murigan had in fact further expanded on those questions, which Jenny will be dealing with for us today. So just some background. Jenny, don't see a shared screen yet. We don't see your.
Okay, let's see if we can get this to work. Sorry, guys.
Thank you.
Okay, let's go here.
There we go.
Right, let's put this on from the beginning. And let's get rid of the presenter view because that's a bit distracting. Are you guys seeing this?
Perfect. Thank you very much.
Hallelujah. There we go. Thanks very much. Can I also just say this session is facilitated also by probono.org. I work quite closely with them in relation to quite a bit of training. And so they very kindly arranged the session in conjunction with Mr. Nell and Mr. Burton. Right, so what do you need to know about POPIA? First of all, you know, we lawyers always have to have disclaimers. This is not legal advice, but what we're hoping out of this is that we'll give you a little bit of guidance about when the neon lights should be flashing, about your things that you encounter in your practice as a sheriff, where you need to stop and think and take advice. The presentation will give you some guidance, but you shouldn't use it as an opinion, because as Advocate Morgan mentioned, your profession is very heavily regulated and you've got different laws that apply to different functions that you perform. The trick with POPIA is always to have a look and see whether you are sticking to the particular laws that regulate the particular function that you're performing. And if you, we'll go through that approach in a little bit more detail later, but the bottom line is, this is a guideline. It's just an overview. I wanted you to have a bit of, you've done this before, I know you have, so forgive me if it's repeating what you already know, but just to give you a bit of an outline about POPIA. So as Advocate Morgan mentioned, it's about the right to privacy and creating some minimum standards to protect personal information. What's very interesting is that our law is drawn largely from the European law, the General Data Protection Regulation. Now, there's a key difference between our law and that of the GDPR, and that our law protects both humans, identifiable living natural people. So if you're dead, you don't get protected by POPIA. And identifiable existing juristic persons, whereas GDPR only protects living humans. We have two concepts that we're going to deal with in quite a bit more detail later, but the concept of a responsible party, who is the person who decides why they need information and how that information is going to be processed. And that is where the POPIA buck stops. So that the Act makes the responsible party responsible for ensuring that the processing of personal information by the responsible party and anybody it appoints to do processing for it is done in accordance with the 8 processing conditions that POPIA describes. Operators are people who do processing for the responsible party, but they do it subject to the control of the responsible party. And it's possible to be both a responsible party and an operator, but not in relation to the same processing of the same personal information. I've put this in here simply so that you can check it. I'm not going to bore you to death by reading it out. The one thing I do want to highlight for you, though, is that a name on its own is not necessarily personal information protected by the Act. And that's because the name in and of itself might not be sufficient to identify the human. Remember, the emphasis here is information which enables someone to be identified. So a name on its own, I mean, I don't know if you go onto Facebook and you put in a name of somebody, or you go online and you put the name of somebody into Google, you might get 100 hits. You won't, with the name only, you won't be able to identify a particular person. And that is why a name in and of itself is not necessarily sufficient to qualify as personal information for the purposes of the Act. Where you put the name together with other information, and that collective information enables you to identify that person, that would constitute personal information. What can't you process? You usually can't process special personal information unless you've got particular reasons to do so in certain circumstances. And I've summarized that here. It's information about someone's religious beliefs, race or ethnic origin, trade union membership, political persuasion, health or sex life, biometric information, and criminal behavior. There's an absolute bar against processing the information of children, again, subject to certain exceptions. Now, we're not going to bore you to death by giving you all the exceptions. I know you already know a lot of this stuff because I've seen newsletters that you've been sent which highlight this, and you don't need that repeated. Do you process when you go and serve documents? Arguably, you do. When you go and execute a warrant, when you receive a document, when you look at the personal information in that document, when you put it into your filing system, when you start sending out an account for providing sheriff services in relation to that document, when you scan it into your computer system, all of those things constitute processing for the purposes of POPIA. Now, these are your 8 conditions, just very briefly summarized. Accountability, we've spoken about that. The buck stops with the responsible person. It's the responsible person's job to make sure that all personal information that is processed by it or for it is done so in accordance with the Act. You should only process lawfully, and there's a list of reasons in section 11 about what constitutes lawful processing. You should process as little information as possible. That's the principle of minimality. You should ideally try and get consent or check whether there's another lawful basis for processing. Now, there's the concept of consent and other bases for processing has become a very prolific area of case law in relation to the GDPR, where the question is, consent can always be withdrawn. So one of the questions that Mr. Morgan asked was whether we need the consent, for example, of bidders to include their information in the bidders report that is prepared in accordance with the rules. And I think the answer to that question is no, you don't need their consent. And I think you need to be careful about asking them for consent, because you have to get that information in order to prepare the bidders report. You're obliged to do so by law. We're going to go through that in a bit more detail later. Where you have to do something, so for example, we as attorneys and you as sheriffs are obliged to identify your bidders and verify their identities in terms of the Financial Intelligence Center Act. That is a lawful obligation imposed on you. And the argument becomes, where we are as attorneys, we act as responsible parties. We're accountable institutions in terms of FICA, and we have to identify and verify the identities of our clients in terms of FICA. We don't need our clients' consent to get their information, and we cannot act for them without the relevant information from FICA. You wouldn't believe how many times I have to explain that to people. But anyway, okay, purpose specification. You should only process personal information for a specific, explicitly defined purpose, and you need to define the purpose up front. Now, this talks to your privacy policy, and you as sheriffs also need a privacy policy. Your privacy policy should explain that you are appointed in terms of laws, you carry out your functions largely in terms of laws, and that for the most part, the work that you do, in my view, is processing related to the judicial functions of a court. So we're going to get to that just now, but ideally you would want that information in your privacy policy. You also need to look at the personal information you process in your businesses generally, and you need to, for example, in your privacy policy, cover the fact that you've got employees whose information you collect, and that you'd process their information for the purposes of their employment contract, for the purposes of giving them employment benefits such as pension fund benefits or medical aid benefits, and you might have to process health information for them in that context, which would be special personal information. That exercise, the exercise of preparing your privacy policy, can only be done once you know what personal information you process, why you process it, why you need it, what you do with it, how long you keep it. So those things all need to be dealt with in your process, in your privacy policy. The further processing limitation obliges you or prohibits you from processing for an incompatible purpose. There is an exception to that rule, and I'm just going to read that out to you. So the exception that you need to remember is in the context of a sheriff's practice. It says here, it's section 15, 3, subsection C, Roman numerals 3. But don't worry about that. You can have a look at the act, and it's in the section under further processing. It says that the further processing of personal information is not incompatible with your original purpose of collection if further processing is necessary for the conduct of proceedings in any court or tribunal that have commenced or are reasonably contemplated. The other one that's relevant is in the interest of national security, and I'm mentioning that because of an exception that we're going to deal with specifically just now. Number 5 is about information quality, making sure that the information you have is complete, accurate, up-to-date, and not misleading. So you have to regularly update information. And one of Mr. Murrigan's questions related to, for example, contact details for people on whom you have to serve process. Do you have to, can you use that information? And I think there is an argument for you using that information. The next question becomes, well, do you have to keep that information up to date, and how long do you keep it? Data subjects are allowed to know what information you've got about them, and you've got to keep records of your processing of that information so that you can say to the data subject, these categories of people have processed your information while it was in my possession or under my control. This again relates to Section 18 privacy notices, which you ideally need to have on your websites or readily available. Security safeguards really boil down to making sure that the information that you have is safe and is not, everybody is vulnerable to hackers, but we've got hackers and malicious people who try and prevent you from operating your businesses by getting you to upload malware. You need to regularly make sure that to the extent that you've got physical systems and electronic systems, that they are as safe as reasonably possible using, and the wording in the Act is appropriate, reasonable, technical and organizational measures. You've got to have data privacy risk assessments, and you've got to have regularly update them. You've got to test your safeguards and keep them up to date. Data subject participation gives data subjects right of access to information, the right to withdraw their consent where their consent was obtained for their processing of their information, to object and to request correction of information. Now, I was asked about whether any of the sections of POPIA don't yet apply. And so I've stuck this in for you, and I've summarized in this column here for you just briefly what these sections were. So the Act really, it's a 2013 Act. And the first bits of it, the definition section and the section establishing the info regulator, came into operation in April 2014. The guts of the Act came into operation on the 1st of July 2020, and everyone was given a year to the 1st of July 2021, when the grace period ended, to get your ducks in a row and to get your POPIA compliance up to date. The obligations to have PIA manuals, which every private body now has to have as well as public bodies. Previously, the law only applied the requirement to have PIA manuals to public bodies, is now effective as well. And you can look on the information regulator's website. They have got a template of a PIA manual. I did compare that template with the relevant sections in PIA, and I think that they've gone a little bit overboard. I like to stick to what you have to have in something rather than sticking in a whole lot of extra stuff. So I'd advise you to be a little bit careful about just slavishly applying the manual. And then Section 58.2 deals with the prohibition against processing certain types of information for which you require the information regulator's approval, such as criminal records, unique identifiers where they're going to be used by other responsible parties and linked with other information, credit reports, and special personal information of children going to jurisdictions without proper protection. 1 February 2022 was the date on which that section came into operation. Now let's get to you guys, and that's the focus of this session, is really about making it practical. So are you exempted? One of the questions I was asked is the exemption under Section 6 for public bodies applicable to sheriffs? So first of all, the important thing to remember about Section 6 is it's not actually it doesn't create a situation where you have a classic exemption where the Act applies to you, but the info regulator says to you, don't worry, the Act doesn't have to apply to you. Section 6 basically sets out a series of exclusions from the Act. And it starts out by saying this Act does not apply to certain kinds of processing of personal information. So that's an important thing to remember. The important thing about Section 6 is there are two sections that I was asked about. The first one deals with public bodies, and I've actually put it in the slide for you because I want you to remember how this works. So Section 6(1)(c) talks about the Act not applying to processing of information by or on behalf of a public body. So we have to ask ourselves, are sheriffs public bodies? Which involves national security, including information used to identify terrorists and related offences, and the purpose of which is, in short, to investigate and identify money laundering, criminal offences, to prosecute criminal offences, and execute sentences and security measures. There is a little caveat at the end there. to the extent that adequate safeguards have been established in legislation for the protection of such personal information. Now, I don't know if any of you have had a look at POCTATARA, which is the act that works very closely with FICA and deals with the protection, with the prevention and combating of terrorist offences, essentially. It is draconian. There are no safeguards for protection of personal information in that act, as far as I'm aware. So I think that, put it this way, I think lawyers would have a field day with somebody relying on this section to excuse you complying with POPIA. So does that mean that what sheriffs do is not subject to, that we can't rely at all on this section to protect you? I think, for example, if you are serving process issued by a court relating to money laundering or prosecuting offenders, subpoenas in relation to court orders relating to money laundering investigations and criminal prosecutions relating to that, you're probably okay, provided you're doing it in accordance with a court order. And the reason I say that is because, okay, sorry, before we get on to that, let's just deal with this question of whether or not you are a public body. So public bodies are state departments and other people, so functionaries and institutions, and I've highlighted in red here for you, who exercise a public power or perform a public function in terms of any legislation. Now, sheriffs definitely tick the perform public functions in terms of legislation box. The concept of public power is really tricky, and the Promotion of Administrative Justice Act talks about it in the context of the definition of administrative action, and very unhelpfully doesn't bother to define it. But this definition is quite helpful. It basically, the concept is about somebody doing something that the government, that is something that the government would do. And I think that where the sheriffs are involved, in particular, I think it's relevant to bear in mind that you guys are heavily involved in making sure that the courts can function. You deliver process from beginning to the end of the process. So you're involved in starting proceedings, making sure that the paperwork relating to the beginnings of the proceedings get to the right people, right through to enforcing the proceedings at the end of the process with arresting people or attaching property and selling it in execution. So do I think you are a functionary or institution exercising a public function in terms of legislation? Yes. Do I think you should rely on this section? But I'm comfortable with that because of this adequate safeguards thing at the end. So you may be able to do so, but I think you've got better protection under another provision of Section 6, which deals with the judicial functions of a court. So this section says, this act does not apply to the processing of personal information relating to the judicial functions of a court referred to in 166 of the Constitution. So that leads us to ask, do the sheriff's functions relate to the judicial functions of a court? What are the courts? Constitutional Court, Supreme Court, High Court, Magistrates Court, and any other court established or recognized. So labor courts, those sorts of things. Has to be a court. Now, I had a look at the Competition Act because it occurred to me that maybe the sheriffs, I know that there's reference to sheriffs in the Competition Act, but the reference to the sheriffs in the Competition Act is limited to sheriffs holding privileged information which has been seized by inspectors in terms of a warrant issued by a court. So once again, we back to sheriffs carry out court orders or facilitate the judicial functions of a court. Right, then let's look at the law, because if we go back to Section 61E, it talks about relating to the judicial functions of a court, okay? Now, your functions, what you do, is all very, very strictly and clearly regulated, right from the appointment of sheriffs all the way through. Even the form for application as a sheriff is prescribed in the regulations to the Sheriff's Act. So there's a lot of detail about who can be appointed, what information they have to provide in order to be considered and interviewed for appointment as a sheriff. Then what the sheriffs have to do, how they have to do it. And the act actually, I've put the wording in here because I want you to see this word shall. So it says here, subject to the provisions of this section, a sheriff shall perform the functions assigned by or under any law to a sheriff of a court of a particular jurisdiction. It goes on to say that a sheriff who's been allocated an area in terms of the act shall perform his functions within that area. In my view, you clearly perform functions prescribed by law, but do those functions relate to the judicial functions of a court? Let's have a look. So there's a Supreme Court of Appeal case which has also been supported by the Constitutional Court, which says that when you interpret any document, a contract or a statute, you have to look at the words within the context in which they appear, taking account of the purpose of those words. So it's a holistic approach. Now, the definition of the verb relate, it means to find or show the connection between two or more things. Now, that's interesting, particularly in the context of what you do. So, but for you are essentially the hands of the court. In a way, the court can't function unless you take process and deliver it to people involved in the litigation proceedings. The court's orders can't be effected unless you go along and you attach goods or you arrest people. So what you do very clearly, in my view, relates to the judicial functions of a court. A court could not function judicially without your assistance. So in my view, if we break down very simply, and I know it's oversimplifying, and I know what you do is very technical in a lot of ways, but what you do is you fundamentally operate as the hands of the court. You execute court orders and court process and warrants. Now, without you, the court couldn't really go out into the real world and function. So I think you are giving effect to the judicial functions of a court. Now, are the court rules? Remember that a lot of what you do is described in the court rules. So the next question is, are you actually doing, when you act in terms of the court rules, which are very specific? We're going to go through some of those rules just now. But when you go through those court rules, are you in fact are you still acting in accordance with the law? Is what you are doing prescribed by law? And that's quite important for reasons which we'll discuss just now. So there was a case in March 2021 where a plaintiff had sued Divine Inspiration Trading and a farm that she visited for damages for injuries she suffered. Anyway, the defendants wanted her medical record so that their psychological expert and human resources expert could assess her damages claim and see whether she was in fact unable to work as she claimed. So a subpoena duces tecum was issued off to the two doctors who were respondents 2 and 3 in the process. And the doctors said, no, sorry, we can't give you the medical records because there's a section in the National Health Act that prohibits us from providing those records to anybody. So the court basically gave the doctors short shrift. And it said, first of all, the doctors were responsible parties vis-a-vis the medical records. Secondly, the obligations of disclosure were imposed on them by law, by virtue of the subpoenas. And the important thing for me is that it says two things: that the legislature never intended to exclude the processing of information where the law requires such processing. And secondly, the rules of court are delegated legislation. And that's important for the purposes of the sheriffs particularly, because a lot of what you do is regulated by the rules of court, the various courts. Then it goes on, the case goes on to say, clearly, the legislature never intended POPI to be in conflict with the rules relating to discovery or the procurement of evidence for trial by way of subpoenas. And I think that subpoenas, remember, subpoenas are just issued by litigants or people involved in litigation. Whereas here we've got the sheriffs who are told by a court or told by the registrar to go and serve a particular document, or by the rules of court to go and serve a document on somebody. So against that background, I also wanted you to think about sections 11.1c and 11.1e. Now, 1c says that, now, this is where information is processed subject to POPIA, because remember, section 11, section 6 deals with absolute exclusions from POPIA. But once you're into section 11, which is having a lawful purpose for processing, you are dealing with processing, which is subject to the 8 conditions. And one of the reasons, there are 2 reasons, or 2 lawful conditions for lawful purposes for processing that may be particularly relevant to sheriffs are processing, well, the one that I wanted to debate with you guys is whether your processing complies with an obligation imposed by law on a responsible party. So the thing we have to think about there is, in performing its functions, is a sheriff a responsible party when he goes out into the world and he serves process? And is that performance compliance with an obligation imposed by law? I think the answer to the second question is absolutely yes. We know that the rules of court are regarded by courts as delegated legislation, and sheriffs serve process in accordance and hold auctions and do sales and execution, all in accordance with obligations imposed in terms of the rules of court and other laws, the Sheriff's Act included. So we tick on that one. Are you a responsible party? Let's think about, I'm going to park that for now. We'll come back to that question just now. And then this was another one that talks about, so this act is yet again not a great example of lovely drafting by our draftsmen, legislative draftsmen, because again, in a way, this repeats a little bit that public law concept, which is in section 6, and it talks about personal information may only be processed if processing is necessary for the proper performance of a public law duty by a public body. Now, we concluded earlier that the sheriff is very arguably a public body because you're a functionary or institution which performs public functions in terms of a law. And are you performing a public law duty? Probably yes. So this section might well be relevant to you. Let's start with your legislation. So first of all, we talked about a little bit about the Sheriff's Act before, and you've got regulations which specifically prescribe what information you have to keep. So Regulation 7 talks about keeping a register of all the process that you serve. And what I've done here is I've copied it out and I've put in red the kind of information that you would need to consider whether it's personal information or not. Case numbers would be unique identifiers. The parties involved, you've got names and who they are in relation to the proceedings. The nature of the process, that may involve, for example, if it's an insolvency process, it may also constitute financial information relating to a person. When you charge for service or execution of the process, and when you send your bill, that constitutes financial information, not necessarily relevant to the litigants, but relevant possibly as between you. It will ultimately be relevant to the litigant, but if the litigant is instructing an attorney, it would be financial information relevant to the attorney and to your contract with the attorney. And any amount outstanding in respect of such service or execution would also be financial information. So you can see that the work that you do in accordance with the regulations prescribes by law that you have to keep certain records containing personal information. Now, somebody asked a question about returns of service. And in fact, it was Ian. Ian and I were debating it yesterday. And the issue was, can you include the instructing attorney's name and details on the return of service? And can you make a return of service available to the counterparty in a litigation proceeding before the instructing person has actually delivered that or filed that return at court? Those are 2 different questions. And I included this Form 10 invoice, which is attached to the Sheriff's Act. Now, I know that this is not strictly speaking for the form that is prescribed for sheriffs. But I included it because I think it's quite a useful template. If you look at it, it says here, you have to identify what you're doing. So the service of summons, notices, letters, you have to fill in whatever it is that you're doing. You have to include the court for which you're designated, the case number. Again, remember that's our unique identifier. The full names of the person on whose behalf process or documents were served and who's responsible for paying the invoice. So in the template attached to the Act, to be used by a designated official who can serve process when a sheriff can't, there's specific provision where the legislature contemplated that the person instructing would have his name and contact details listed on the invoice. The rest of the document looks like this: what you did, the amount that's payable, so that's the financial information again, bank deposit reference, so your receipt number, the amount that's payable, and signatures, all of which are personal information. And this is in a standard form invoice. I simply included it for interest. If we deal with laws regulating sheriffs, we go through to Ian. I see I've got lots of stuff on the chat. Are there questions? Have we got any questions yet?
One question has just popped up, and a second question is just in the chat. It's something different. Do you want me to ask the first question quickly for convenience?
Sure, absolutely, no problem.
Okay, I've got no idea who asked this. It's
doesn't matter
by name, but the question is: a sheriff serves a copy of the summons on the defendant's neighbor. Is he contravening POPIA?
Can we park that? We are going to get to that. That question was asked specifically by Advocate Morgan. So we will answer that question in a few minutes, if that's okay. And then do you want to ask the second one, Ian?
Yes, this is from Pietro Ruet. Says, hi, Jenny. After a sale and execution, the sheriff is responsible to sign all documents to effect transfer to the buyer. The sheriff is therefore requested to sign documents on behalf of the existing owner. Apart from the transfer documents, the conveyancer also includes a POPI document requesting the sheriff to give permission to the conveyancer to use the debtor's, the existing owner now, that person's personal information. Is this correct?
Okay, the short answer is I don't know the answer to that, because we've got to go back to your enabling legislation. So a lot of the questions that I was asked gave rise to, you have to go back and look at your enabling legislation. So we've got to go and look at the legislation regulating, that would be 45A, wouldn't it? Rule 45A, Ian? Because it's immovables.
It's immovable. High Court Rule 46 and 46A.
Sorry, 46.
That's right.
Here we go. Execution of immovable property. So the debtor's information, no, but hang on, let's think this through. So the debtor has now had a property sold in execution. That was a public process. Where the information, remember we had that earlier. So first of all, I don't think that they need to sign a POPIA thing, because the execution process, including the transfer of the property, that's the end of the execution process, which is giving effect to the court order saying, go and attach so-and-so's property, sell it in execution and transfer it to the buyer so that the creditor can get paid. That's the ultimate, that's the last part of processing required to give effect to, in my view, to the judicial functions of a court. A court gave an order saying, go and sell that property in execution and transfer it, and then take the money and give it to the execution creditor. So I think our argument would be, firstly, that it would be subject to the exclusion in 6E, which says that the Act doesn't apply to the processing of personal information relating to the judicial functions of a court referred to in 166 of the Constitution. If it does, and the fact that you say to the conveyancer, listen, I don't think POPIA applies to this, doesn't mean that they're going to accept what you say. Remember that the debtor's details have all been made public in any event, in the court process. All the pleadings, the whole court process is public in the usual course, unless you're dealing with children or sensitive criminal matters where people are only referred to by initial. So in that instance, Ian, I think there would be an argument for saying, just referring to the fact that the transfer is in accordance with the court order, and that the debtor's information is contained in the court order, and that should satisfy the conveyancers.
Thank you very much, Jenny. Thank you.
I don't know if that makes any sense. The one thing that I became very aware of in going through the relevant sections to try and find the answers to your questions is that we have to go back to the specific law every time and say, well, what does this law say? What are we doing in the context of this law? And does that track back to the Section 6 exemption or exclusion for doing processing which relates to the judicial function of a court or not? And if it's subject to POPIA, are we processing in accordance with the 8 conditions? And there, you can't transfer the property, presumably without giving the information of the debtor. But the debtor is the owner of the property anyway. So the conveyancer has to know who the owner of the property is that is being sold in order to be able to effect transfer. So to give effect to the court order, that information has to be given to the conveyancer. I don't know if that logic makes sense. Okay.
Yeah, thank you very much. So in principle, the POPIA is there, but that will mean that you don't need to sign, because we've also had it in our office. So you don't literally need to sign that form that the attorney sends you, because you are still acting within the scope of and your mandate that was issued by a court. So I
would just do an email back to the conveyancer saying, thank you very much for your, please note that first of all, the debtor's information is part of a public process, litigation process. And in addition to that, this is the final part of giving effect to a court order to sell this property in execution.
Super.
I do think it may be something worth looking at, getting a senior counsel. It might be at some stage be worth, if you keep getting pushback on this from various people, it might well be worth getting a Silk's opinion on whether the Section 6 E exception or exclusion applies to sheriff's functions in execution and serving process, because then that opinion could be used to deal with all these queries. Okay.
Thank you very much. Before we move on.
Yeah.
This is one of the questions that we discussed when we spoke. Again, it's from an anonymous attendee. It says, a bidder participating in an auction requested the names and details of the other bidders in order to establish if collusion has taken place. Will I be contravening POPIA if I provide the successful bidder with the bid register?
Okay. Let's have a look. Sorry, we're going to skip forward to do this, to deal with this. You know what? Sorry, can I be very rude and just ask if we can park that one as well, because we are going to answer that. I've dealt with it specifically in the context of bid registers or bid records, I think they're called in rules. Okay, so let's, yeah, just keep it there, Ian, and if I forget, will you just remind me, please? Okay, so let's deal with, so here, this is, you know, for me, we lawyers always go back to the law. So we start with the Superior Courts Act, which says, Section 43, execution of process by the sheriff. The sheriff must, subject to the applicable rules, which remember are delegated legislation according to divine inspiration, execute all these documents directed to the sheriff and must make return of the manner of execution thereof to the court and to the party at whose instance they were issued. So Ian, your question the other day about what happens when the counterparty, the person who's been served with the process, comes and asks for a copy of the return because the days begin to run when service was effected? I was going to ask you, by the way, practically speaking, when you serve the process, do you not give a copy of the return to the person who is served with the process then and there?
No, ma'am. The return is only prepared once you're back at the office, and the return is only processed at that stage.
Okay. Okay. So I think the answer to the question is, so Ian's question at that stage was, can I give a copy of the return to the counterparty if the person who asked me to serve the process or execute the process is slack about filing the return of service and picking up the return of service and filing it at court? And I think the answer to the question is in these words: direct to the sheriff, and the sheriff must make return of the manner of execution to the court and to the party at whose instance they were issued. So Ian, I think in that scenario, if you sent a copy of the return of service to the court, you would be complying with this rule and enabling the counterparty to deal with the legislation promptly. I mean, to deal with the litigation promptly. So I think that would be the answer there. The wording here, I want you to pay attention to the word must. This is a compulsory obligation imposed by law on the sheriffs. You are acting in accordance with your legal duty when you do this stuff. Then it goes on to say a refusal by the sheriff to do any act which he or she is by law required to do is subject to review. Now, the interesting thing about that is, remember we spoke earlier about whether sheriffs are public bodies. So reviews are usually only applicable to administrative action carried out by organs of state or public people exercising public powers or performing a public duty. So institutions or functionaries who do that. And we spoke about that earlier in the context of PADGA. So I think this reinforces my view that sheriffs would be regarded as public bodies, or public bodies in the sense that you are institutions carrying out a function, a public function in terms of an empowering law. Now, what do you have to do when you serve or execute court process? Stick to your particular law. So go back, look at your rules, see what your rules say, and make sure that your returns comply with the law, that the information in the returns is that which is described in the law. The minute you start going outside the law, the processing may fall outside the exclusion of processing required for the judicial functions of a court. And then you might have to comply with the POPIA conditions, which isn't necessarily the end of the world. But at the end of the day, if you can avoid complying with POPIA altogether, that, by the way, does not mean that you can be negligent or careless with somebody's court process. So you should be careful with it, because the minute you are negligent or careless with it, and the information is stolen or lost or something happens to it, then the loss of that information might in and of itself bring that information within the scope of POPIA. Alternatively, you would be disciplined under your code of conduct. Okay, let's deal with that question about, can you serve on the neighbor? Now, I know you know this. Sorry, Ian.
My apology. Just a quick one. Michelle Jones, she says, hi, Jenny.
Yeah.
She's referring to the POPIA in terms of information that needs to be provided for claimants, for example. So she says, hi, Jenny. So this obviously means that the POPIA Act form then applies to interpleader claimants and the proxies as well, or yes. So interpleader, again, it's a process that is you are delegated by the rules on how to follow the process, and in that process you will then provide information of the claimant who is claiming ownership of the goods. And the question, if I understand the question correctly, is, would that POPIA form then will it then be used for the claimants in the interpleader process as well?
Okay, but again, the interpleader process is something that is done in accordance, it's part of the court process, isn't it, Ian?
Yes, it is, ma'am.
Because interpleaders are where somebody say, that property is actually mine. You can't sell it in execution or you can't attach it. Isn't that fundamentally what it, I mean, it's donkey's years ago since I did litigation.
Yeah, no, you're quite correct.
Okay, so with that in mind, again, we come back to when you deal with an interpleader and so the question, as I understand it, is if I give the claimant's name and personal information to somebody to enable them to bring an interpleader application, am I contravening POPIA? Do I have to comply with POPIA? Okay, so the question there is that process part of the court process, the litigation process? So if somebody, I think you would be required to take reasonable steps to make sure that the person concerned was genuinely somebody who wanted to bring an interpleader. You can't just dish out the information without making an inquiry, a reasonable inquiry as to whether the person who wants the information is actually who they say they are. It's a little bit like your buyers. You're obliged to identify and verify the identities of your buyers when you for a sale and execution. So I think you'd need to have a little bit of you'd need to be a little bit careful there. But yeah, I think there, provided we can show that that whole process is again part of processing relating to the judicial functions of a court. Once again, we outside POPIA altogether. But if it's not, then you need to manage the process. You need to make sure that the information, when you, again, this comes back to your privacy policies. If you as sheriffs have identified interpleaders as an instance where you would not be processing in accordance with the judicial functions of a court, then in your privacy policy, you need to say, when you as a claimant, when we become aware of your personal information as a claimant, and we make that information, we may be obliged to make that information available to a potential interpleader person. And we're telling you that we're going to do that for that purpose. Do you think, Ian, are you comfortable that that addresses or at least creates direction for the way to find the answer to that question? Okay, that's great.
Thank you very much. Thank you.
Let's do the neighbor. So can you serve on the neighbor? So you've got a very, very long list of situations that are provided in Rule 4 of the High Court rules. And I've only dealt with the High Court rules because I understand from Ian that, that since I did litigation, they've largely been, the Madge Court rules and the High Court rules have largely been made as similar as possible. So you can deliver to someone personally. And if someone's a minor, there's a whole long list of people you can serve to instead of the minor. You can leave a copy at the place of residence or business of the person, or somebody apparently in charge of the premises at the time. And where it's occupied by somebody else, you can serve on them. By serving a copy at the place of employment, again, somebody apparently not less than 16 years old. If the person so to be served has chosen a domicilium, at the domicilium. So the answer here is that you're not allowed, it doesn't say here that you can serve on the neighbor, because if you're serving on the neighbor lives next door, don't they? They don't actually reside at the premises. So we go back to by leaving a copy at the place of residence or business of the person, with a person apparently in charge of the premises at the time of delivery. So I don't think it allows you to serve on a neighbor. I didn't put the whole rule in here because it got very long and boring. But in certain circumstances, you can also leave a copy at the domicilium so chosen. So where somebody's chosen a domicilium, you can simply affix the process to the door. You're allowed to do that by leaving a copy at the domicilium so chosen. It doesn't tell you how you should go about leaving that copy. So maybe if someone is not present and it's their domicilium address, you could serve it there. The affixing a copy to the main door is specifically provided for in relation to corporations or companies. But I think if it's a human you're serving on, it's got to be at the place of residence. It can't be next door.
Well, while we're on that question, there was a question that that was posed. Thank you very much for dealing with that one regarding the neighbor. There was a question posed. So what if an attorney gives you an alternative instruction to affix a document, even though it is not cited as a domicilium, because then it is not in accordance with the law?
Okay, so
refuse to serve. Now, I know this is a difficult one because this is like interpreting the rule now that guides us, not the POPI, the POPI Act.
but the point you make is excellent, Ian, because at the end of the day, and the question is brilliant because it helps us illustrate the point that if we are saying that we as sheriffs are completely, that when we perform our functions and those functions relate to processing relevant to the judicial functions of a court, we can only rely on that exclusion if we stick to our knitting and only comply, do the service or execute the process strictly in accordance with the rules. If the attorneys now, it's not for the attorney to tell you how to perform your functions. You don't work for the attorney. You work in terms of the rules. You are appointed by the Minister of Justice. You're an independent person and you carry out public functions. You perform duties prescribed by law. So you don't do what the attorney tells you to do. I mean, if the attorney told you to do something which was completely outrageous and absurd and not contemplated by the rules, I don't think that that's a valid excuse for doing that. You do what the rules allow you to do. You can only give a return of service. I mean, surely that would give rise to a deficient return of service because you haven't then served in accordance with the rules of court. So I think that's quite a dangerous road to walk. And I do think that it's relevant to POPIA at the level that if you're going to claim that you are, that what you do is excluded from the scope of POPIA, you have to do only what is processing required for the judicial functions of a court. And that's regulated by law. The minute you step over that line, you are exposing yourself to a claim that you are now processing for some other reason, for some other purpose, not related to the judicial functions of a court. And even though it might be lawful, you need to then consider very carefully your risk because you are now obliged to comply with the 8 conditions when you process that information. I hope that makes sense.
Right.
Because essentially, that's the gist of this presentation is go back and check your rules. I mean, I always, there are some things that I always go back and check and never ever trust my memory on the specifics of the law in certain respects. And I think it's well worth checking your rule just to make sure. And when you create templates for yourselves, for example, of invoices or of that you use in your business, go back, look at the rule, see what the rule says you can and can't do, what information you would necessarily have to have in your template, in your return of service to be able to comply with that rule, and put it into your template and don't ask for more unnecessarily. Okay.
Thank you.
Do you think that answers that?
Yes, thank you very much. It does.
Is there another one?
There's a few.
Okay.
Just a quick one from Mr. Mohammed Asma. It says, good day. Will Section 1E cover a sheriff for documents that are not issued from court? Example, Section 129 notices. Now, these are notices.
Okay, I haven't a clue. Again, the answer is we have to go and look at the particular section. Section 1E of the Superior Courts Act.
I think he's referring to Section 1E of the POPIA Act.
Oh, I did look at, oh, okay. 1E of the POPIA Act.
Because the Section 129 notices, all the notices, it's the letter of demands that are issued by some of the banks via the sheriff, and there isn't
a Section 1E. There's no Section 1E of the POPIA Act. Because one is the definitions.
Okay.
Won't you
Okay,
clarify the question, Mr. Mohammed?
I'll check whether he has a response. Just another one from Mrs. Ruitt. Is there any obligation on the sheriff to protect information such as employee records and financial information when goods sold, such as filing cabinets containing such records, are sold on auction?
Okay, my first observation is I'm horrified that filing cabinets get sold with employee records in them. Why would filing cabinets ever be sold with records in them? If it's a sale of a business as a going concern, that's the only circumstance in which I could imagine filing cabinets being sold with records contained in them. Would that happen?
I'm not sure. Maybe Mrs. Ruitt has had experience with that, or something has happened. You see, it's very difficult. We have so many different scenarios when goods are sold on site, or when there's a premises sale and the goods and the items, like for example, documents are inside of cabinets, whether they are locked or opened. So I'm not sure what the scenario she's referring to. I think it was a general question.
I think it's an excellent question. And if we go back to base principles, so if the asset being sold is in fact the filing cabinet, then I think it becomes very dangerous to sell a filing cabinet with documents contained in it. Let's imagine we had a filing cabinet that was full of health records or the records of children. Now, we as the sheriffs have sold these records and passed them on to who knows where with no precautions, no steps to protect. I think that would be very problematic. My view would be all filing cabinets should be opened, and all so the same excellent point though. If, for example, you have computers, where it becomes tricky now, and I think something we'd need to think about is whether if you're selling computers and you're selling computers that have got hard drives which are not wiped. Now that computer's got a whole lot of information, personal information on it, which might be highly sensitive, like bank details, children's information, all that sort of thing. Now the question becomes, well, shouldn't you be getting an IT expert in to reformat the hard drives? And is that the job of the sheriff? Because I definitely don't think you want to be selling computers containing a whole lot of personal information willy-nilly without any kind of precaution. It's an excellent question. Sorry, let me just say this. I am not an expert in sheriffs. As you heard at the beginning, I'm a commercial lawyer. So Ian has very kindly held my hand and explained how your processes work. And you guys really have a tough job. Honestly, you do deal with so many different factual situations. And that's why what we tried to do with the questions was to look at those factual situations and try and give you a bit of a steer in terms of how to deal with them. Off the top of my head, don't sell filing cabinets with stuff in them. Don't sell computers unless you've reformatted the hard drives.
Thank you very much.
For me would be a minimum precaution.
Okay.
Because you're not.
Yes.
So what? Okay, can I give you another scenario? So let's say we have a computer, and part of what we're selling is the IP that is on the computer. Would we ever do that? I don't know.
That's a very good question.
So if we're selling IP that is on the computer, then that IP and the information, the personal information contained in that IP would need to be preserved, or maybe saved onto a separate hard drive or something, and then the computer reformatted. Because remember, every email's got personal information in it. This is why people have to do the data analysis up front. So let's just take a step out here and assume that sheriffs, so we've got two functions. Remember that in your jobs as sheriffs, the work that you do, I think, is largely excluded from the scope of POPIA by the section 6. That's my view. As I say, I think it would be worth probably spending a bit of money getting a Silks opinion that you could just wave at anybody who argued with you about that as a standard thing. But there are still things that you as sheriffs do every day that are subject to POPIA. So when you deal with employees, your own employees, when you deal with financial records, when you deal with your customers, who are essentially the people instructing you to serve process, all those things, you're going to be gathering personal information. And in relation to the handling of that personal information, you have to comply with POPIA. So you can't have a receptionist, for example. This is my favorite. And I mean, I saw it happen in real life. So it happens. I went to the doctor's one day, and there was the receptionist chatting away on the phone to somebody, giving them test results on the telephone in the open reception area. So everybody in the reception area could hear who the person was and what the test results were. Now, there you're dealing with health information, which is being publicly disseminated because of where the conversation was had. Now, the same would apply to a sheriff. Let's say, for example, we had an attorney who was urgently, you were instructed and you needed to urgently go and serve something, and the counterparty to the litigation happened to have a contact who was standing in the office, and your receptionist was talking to the attorney on the phone and getting all the details and repeating them on the phone as they were written down. And this person heard what was going on, ran off back to the counterparty and prevented the matter from proceeding. You know, harm can result from dealing with that. You've got to be careful what you say on the phone, and you've got to be careful where personal information is handled in your office. You can't have your employee records, for example, lying on top of a desk or in an open filing cabinet. They need to be put away. So I don't know if that answers Mrs. Roos's question.
I think it does. I'm going to try and ask two questions simultaneously now, because we've only got about 45 minutes left.
Oh, shoot. Okay.
My sentiments, exactly. So Mr. Dawood is asking exactly the same question that I posed to you. When affixing a document at a domicilium address or even at a residential address, the contents of the document is visible.
Is it private?
Well, if it's a summons. So if that document, let's use a summons as an example, and you affix it to the front door, and for example, the residence does not have a fence, so it's not fenced in. Anybody walking past can see the document with all the information on the document. Is that a contravention of the Act?
No, I don't think it is, for two reasons. Okay, reason number one is I don't think that the process of fixing it to the door, provided you're complying with your rules relating to service, you are processing in relation to the judicial functions of a court, in my view. And so POPIA doesn't apply at all. Secondly, a summons is a public document. So the information contained in that summons is public in any event. So it's not like you're prejudicing any data subject whose information is contained in that summons, because anybody can go down to court, call for the court file and have a look at the content of the court file. Okay, sorry, Ian, you said there was another question?
Just to come back, Mr. Mohammed was referring to section 6(1)(e).
Yes.
And then Mr. Tembe, one of our colleagues, answered him. He was asking the question about the 129 notices, and then Mr. Tembe answered and said that in terms of the way it's being done, the 129 notice is very important because it's a step in the judicial system in terms of letter of demand, then summons, blah, blah, blah. Okay. And the Consumer Act, the Protection Act, actually guides you in that. So the question was, would you be, as a sheriff, be covered by section 6(1)(e), but when you serve the 129 notices? And I need to point out that many of those notices refer to the service address as the domicilium address.
And Ian, sorry to be so stupid, but are we talking about 129 of the National Credit Act or 129 of the Consumer Protection Act?
Consumer protections.
Which says what? Sorry, I haven't got my act at hand.
And I'm not going to lie to you, I don't have it in front of me. So I'll have to find out. I can get it. But we received just an example, we received those Section 129 notices, more especially from the banks when it's regarding HP of a motor vehicle. And those are the letter of demands that are being served.
Oh, okay. So those are repossessions.
Yes.
Essentially, I'm coming to repossess the property. Okay, but again, that's part of a court process. Ultimately, it will ultimately result in a court process.
Correct.
Okay, so yes, so the whole point. Let's take the first one. Section 6(1)(e) is what, in my view, excludes most of what sheriffs do in terms of their daily work up here. Okay, so I agree with Mr. Mohammed on that, but that's the one where I say so that you've got a bit of backing, so that you've got a bit of clout. If everyone gives you a hard time about that, that's where I suggest that you go and get a view from a silk, that you can wave at anybody in that regard. Okay, that's the one. And then the second one is the 129 process in terms of the CPA. So again, if we're dealing with a court process, I think it's judicial functions of a court. So that would be, again, subject to the exclusion. Alternatively, you would be processing, if we look at Section 11, you would be processing. Processing is necessary for the proper performance of a public law duty by a public body. So you would have to serve the 129 notice to properly perform your public law duty in terms of 129 of the CPA by you, the sheriff, a public body, being a functionary carrying out the public duty. But again, then you're required to comply with POPIA. Okay. And I think there's fundamentally a disjunct between the concept of a sheriff serving documents which become public in a litigious process and privacy. So provided you stick within what the law allows in the work that you do, very clearly within the work that you do, and you can always point to a piece of legislation and say, in terms of that rule, I've taken your name and your ID number and proof of who you are, and I've kept that on record, and I've sent that to this person or made that available to this person, then I think you're okay. So let's go on and deal with that question about, can you give the bidder's record to somebody detailing all the bidding information? Let's just zip through these questions, which were the ones that Advocate Morgan asked. What are the requirements for you to comply with POPIA? Exactly the same as everybody else. So if and to the extent that POPIA applies to all or part of your business and work that you do, you've got to comply with it just the same as everyone else. How should you handle court documents containing personal information? I think that your processing of personal information relates to the judicial function of a court, and therefore I think it's excluded from the scope of POPIA. But I caution you that if I think you are negligent or careless with court documents, you're not processing. Your processing is not permitted in accordance with the judicial functions of a court, and you might not be able to rely on the 6(1)(e) exemption or exclusion. So the reason I say that is I found an article dealing with divorce cases and discovery in a divorce context under the GDPR. And it cautioned that although proper discovery of relevant information is protected and is permitted, and the GDPR doesn't apply to that, the minute you start discovering irrelevant information, you fall outside the scope of the protection and you are subject to GDPR. Okay, when serving a document on a third party, is a sheriff contravening POPIA, especially when serving on the employer, the debtor, or the co-worker? Okay, so presumably here, if you are serving on a third party, then provided your service complies with the rules, and remember one of the rules specifically said you could leave it at the place of residence or business of the person, with the person apparently in charge of the premises. So it needn't even be the employer, or you can leave it at the here it said, deliver a copy at the place of employment with anybody over the age of 16 years. Doesn't have to be the employer. Okay. When serving on the employer, the debtor, so presumably there, the debtor is in fact the defendant, but maybe not, or a co-worker. So we back to, what do your rules say? Go back and look at your rules and see whether these instances are covered by your rules. When serving a document on a third party, are you contravening POPIA? Oh, that's the same one. Oh, these are the additional 2 points I wanted to make in this regard. First of all, this is a bit like sticking it on the door. The process is a public document. Service relates to the judicial functions of a court. So I think you're okay there. What about service on a domicilium address when you've moved? So the wording of the rule is, if the person so to be served has chosen a domicilium, you can deliver or leave a copy thereof at the domicilium so chosen. So even though they've moved, first of all, how do you know they've moved? If somebody says at the premises, oh no, so-and-so is not here anymore, he's moved, how do you know they're telling the truth? The rule says, if they've chosen a domicilium, leave it at the domicilium. If you think, however, that they appear to have moved, that might be relevant information for the necessary for the purpose of informing the court whether the person in fact, there was a real chance that they in fact received the process. But the rule allows delivery at the domicilium. Does POPIA govern the processing of contact details of people on whom process is to be served? You need the contact details to serve in accordance with the rules of court, then arguably you're processing them in relation to the judicial functions of a court. But I would keep that information confidential. I would think about it carefully with a view to, how long do I keep it? How do I keep it? Do I have proper, I'd probably treat that as if it's extra information which helps me perform my statutory duties and to which I'm going to apply the POPIA conditions. Does a summons have to be enclosed in an envelope? I don't think it does, because it's a public document and because it's being processed in relation to the judicial functions of a court. So the answers to those two questions, I'm sorry to be repeating myself, but I think that those would be the answers there. You got another one, Ian?
I'm sorry. Yes, I do have. Annette Janssen van Rensburg asked, if you arrive at a premises at the address of the defendant, and you inquire from the person that you meet there, if they are the correct person, are you not contravening the POPIA Act by giving information that's on the document out prior to confirming who resides at the address?
So if you say, are you so-and-so, you're just using the name?
Yes.
So remember what we said at the beginning, a name on its own is not necessarily personal information. So, and I mean, to be able to serve, you need to make sure that the person you're serving on, ideally, is the person cited in the relevant process. So I think if you just trundle into and throw the document at anybody there without checking who they are, without trying to make an effort to make sure the document is served on the right person, I think that might also give rise to people saying that you haven't complied with POPIA, because say there's information, say there's a divorce proceeding, people get very sensitive about divorces, and say you go to premises and you say, I need to, are you so-and-so? I want to serve a document on you. And they say no, and you then serve it on somebody else. And that person, by virtue of receiving the document, becomes aware that the person actually lied to you and they were in fact the person that you were supposed to serve on. It's not your fault that you've given it to somebody else, but now it may be embarrassing. I don't think it's a POPIA contravention that somebody else knows that the person concerned is getting divorced. Am I illustrating the difference?
Thank you very much.
I appreciate people get very twitchy. I mean, I see it every day when I ask companies for copies of their share registers so that we can comply with FICA. Oh no, we can't possibly see their share registers. Well, it's not a private document. The Companies Act entitles you to it. A court process is a public document unless there's special rules around confidentiality in relation to that document. That doesn't necessarily mean that you should be cavalier with it. You obviously need to take steps to try and make sure it goes where it's destined. Sorry, Ian, you look as though you got another question.
Yeah. The two questions that I have left is the initial one regarding the successful bidder and the information.
We're getting there.
And then there's another one pertaining to the sale and executions. But I see Mr. Klaas Volker asked a question where he says, by putting a notice of sale on the notice board of court or at your office, are you in contravention? And it's a very simple no, because that's the instructions as per the execution process.
Yes.
It's per the rule, so.
Absolutely. But now, okay, so what can you put in the notice? If you put a whole lot of extra stuff in the notice that isn't prescribed by the rules, are you contravening POPIA? To the extent that there's extra personal information in there that isn't in the rules, you might be contravening POPIA. So again, I come back to go and look at your rules, see what you have to put in the notice. Putting a notice that complies with the rules on the notice board at court and on the premises that are being sold is prescribed. You have to do it by law. Okay, so what about processing of your personal details, including your bank details? Should you get confirmation of compliance with POPIA by, how much time have we got? 25 minutes. Okay.
25.
So the question there, the thing you need to think about is whether you are disclosing whether you're processing the information, or whether the person to whom you're giving the information is processing the information as a responsible party, where they determine what information they need, why they need it, and how they're going to process it, or whether that person is going to be processing it for you and essentially carrying out part of your duties as a responsible party as your contractor. If somebody is a responsible party, let's say your accountants, they are now doing your books and they become aware of the names of all your customers because they look at all your invoices to do your audit. Do you need to have a contract with them? Strictly speaking, you don't. Lots and lots of people, though, do conclude some kind of record of the arrangement or agreement between responsible parties. Firstly, that they both agree that they are responsible parties. And secondly, that they are going to comply with certain standards of security in relation to the personal information that they will be processing, and keep that information confidential. And that, as a responsible party, if you are giving personal information belonging to third parties to your accountants, for example, you would want to be sure that they are going to treat that in a carefully and securely. Where the information is being processed by an operator, so let's say you send your documents off to an archiving service to be archived. Now that storage, they are doing that for you. You don't tell them, sorry, and I'll just finish this point, then I'll come to you. They don't tell you what information they need, how it's going to be processed, and why they need it. You tell them what they need to store and how they must store it, and you need to satisfy yourself that proper security proceedings, security measures are in place. Then they're an operator, and you need to have a data processing agreement in terms of Section 21 of the Act with that person. Okay, do we have another question? I saw a hand went up.
Yeah, this is just a quick one. The gentleman is what's being asked. Some estates require you to give information about where you are going to security, or they escort you to the premises where the service needs to take place. Sometimes you have to fill in a register with the name of the person you are visiting and the address where you are going. But those are terms and conditions of the body corporate. That has got, that is a requirement by their body corporate for you to enter the property. Whether you give the name or not, whether you were a sheriff or whether you were a visitor, you were going to give the name anyway to get to the property. So I don't think there's any issue there.
Yeah, I mean, I'm based up in Joburg, and to get access to estates, they often scan your driver's license. And lots of people don't think about that. And they don't think about how long is that data kept? What happens if somebody hacks that data? I mean, I had somebody the other day who refused to provide a copy of an ID. I mean, I did point out that basically every South African who was born before 2012 has their personal information on the dark web because the Department of Home Affairs had a contractor who made it available, but we won't worry about that for now. Okay, so I think that answers that question. How does POPIA affect, Section 45 prescribes conduct of auction. So this is now, we're going to deal with your sales and execution. And in your the bidders question, the bidders record question. So Section 45 of the Act says how you must conduct an auction, and it includes in the definition of an auction sales and execution. So how does POPIA affect you when you collect personal information of bidders and you distribute it to third parties? Well, Regulation 26 to the CPA requires that an auctioneer must have a bidder's record, and it says you have to record the identity of every bidder as identified and verified in terms of the Financial Intelligence Centre Act. Of course, it refers to regulations which have subsequently been repealed, so I'm not quite sure how they work that out, because now in terms of FICA, you're obliged to identify and verify people on a risk-based process. But you, for example, would need to get copies of IDs and that sort of stuff to make sure that the person is who they say they are and they're not a terrorist or a money launderer. The bidder's record listing only the bidders' names and bidding numbers issued by the sheriff must be publicly available. So only those two pieces of data. The number that's issued by the auctioneer would be a unique identifier, remember? And that list showing only the names and the numbers must be publicly available during the auction at the place where the auction's held and before and after the auction. That is what the rule says, the regulation says. So the question is, can you now put the person's ID number, telephone number, address, all that available on the bidder's record? I don't think you can. I think you have to stick to the rules. Go back to the rules, look at the regulation, see what it says you must make available, and put it in there. Can you make the bidder's record available to somebody outside of these times? It has to be publicly available during the auction, at the place where the auction is held, and before and after the auction at the sheriff's office. So that part, it's a public document, but all that's allowed to be in it is the bidder's names and numbers. And remember, the names in and of themselves don't help us a hell of a lot. Okay, then the next thing is, what do you need to know about collecting, distributing, and holding personal information of bidders? To be protected by Section 6, you only need to collect, distribute, and hold what is expressly required by law. Or if, for example, you need a contact number to be able to get hold of somebody to be able to comply with your obligations by law, maybe that's excused. Do you need to get buyers to sign a disclaimer? By that, I presume you mean a consent to the disclosure of their personal information. I don't think so, because once again, you're collecting the data in accordance with a rule. You're only making available certain bits of that data in the buyer's record. And you're doing what you're required to do by law, and the processing, again, is related to the judicial functions of a court. Do you need to have a notice board drawing the attention of the public to the fact that you're processing personal information in relation to auctions? Again, strictly speaking, no. But this goes back to your privacy policy. Your privacy policy should include the purposes for which you process personal information, including where you do so by law. So if your business is the business of a sheriff, put it in your privacy policy and refer to the relevant laws. Okay, now here, the bidder's record. 28.4 lists the obligations. So this is the vendor's role. It has to include the bidder's record, declaration of ownership of goods, names of the successful bidders, the goods or lots bought and the prices paid, details of any challenges to validity, items or lots not sold, details of any reserved price. And the vendor's role, it says Regulation 24N prohibits the hindering of access of any person to the vendor's role. Okay. What is the impact of POPIA on sales and execution concerning registration of buyers? You've got to go back to the regulations, read with Section 45. So go back to the Act. Distribution of information to prospective buyers relating to sales and execution may include the personal information of litigants, and how should that be handled? If it's in the court documents, it's already public, and processing related to the digital functions of a court, which is excluded from the operation of the Act under section, in my view, under Section 6. If the information is included in accordance with CPA and its regulations, it's prescribed by law, but it also relates to the judicial functions of a court. Now, this reserve price reports. So this is when you're now reporting. Sorry?
Can we just ask 2 questions before we go to the...
Yes. Do you want to go back here?
Yeah, just quickly there, yes. So the question that was posed initially is whether you could then provide, would you be contravening the POPIA Act if you provide an individual requests the names of the successful bidder. So to clarify that, you can only supply the name and his bidding number. That's it. So, and then the next question is, would a defendant or the debtor or the respondent in this matter be within their personal rights to demand information of the buyer of their property sold on auction? Does the sheriff have to obtain permission of the buyer in terms of POPIA? And that is something we also discussed.
Yes. So here, the vendor's role includes the bidder's record, and here it says names of successful bidders. And that, it says here, Regulation 24N, unless I've misunderstood this, Ian, it seems to me that the person who successfully buys stuff in a sale and execution will have their details included on the vendor's roll, which is dealt with by Regulation 28.4 to the CPA. And it says, Regulation 24N prohibits the hindering of access of any person to the vendor's roll. So again, go back to what the Act says, go back to what the regulations say, and say, well, okay, you have to make that information available. You can't hinder access of any person to the vendor's roll.
Okay, but just to make it a little bit more complicated, and we are running out of time, we've got 15 minutes. The problem is that this section, as I'm seeing it now, refers to movable property. It's stuff that can be...
Okay, so we're talking about immovables now.
I'm talking about immovable because at the end of the day, the conditions of sale is completed by the successful purchaser. And that includes all his personal information, not vending roll or registration information.
No, yeah.
I think that is important to differentiate between the two, as I explained to you, because I personally will not just indiscriminately hand out information of a successful purchaser on my auction after the completion of the conditions of sale. They can obtain that from the registering attorney, the transferring attorney, or the instructing attorney. But
and Ian, we discussed this the other day, and you said that ultimately that information finds its way into the court file anyway, doesn't it? Because you have to report to the judge on the outcome of the sale.
Only if the registration, if the reserve price was not met. When you compile only in that, the conditions of sale does not end up in a court file somewhere, because that goes to the transferring and registering attorneys.
Okay. Okay, so once again,
to be attended to. But the only information that ends up for a judge.
Okay, so then the answer to the question once again is go back and check the relevant rules dealing with the sale of immovable property on auction and see whether you are obliged to make the details of the successful buyer available publicly. If you're not, you can't. You're not authorized to do that, because remember, you are essentially only permitted to do what the law says you can do. Okay, we've dealt with that. All right, 46.9D is the reserve price reports. So where it's not achieved, you have to report to court, and you include there the highest bid or offer made and the names, identity numbers, and contact details of the people who participated in the auction. Now, remember, there may be a difference between that list and the list of bidders, but the list of bidders is going to be that bidder's report. The only bits of that can be made publicly available will be the names and the bidding numbers. So again, relates to the judicial functions of a court. The report goes back to court, and you might have to put other information in required by the court to help it perform its functions in paragraph C. So pretty much everything you do, it seems to me, is prescribed by law. So to the extent you stay within your empowering laws, and those laws relate to processing relating to the judicial functions of a court, then I think those functions are pretty much excluded from the application of POPIA. But you've got to be really, really careful. You've got to go back, look at the relevant rules, the points you've made, Ian, the fact that you identified that the one set of rules deals with sales of movables, and that the rules for that differ from the sales for immovables is very important. Go back, check your rules, check what kind of property you're dealing with, and make sure that you are complying with the relevant rules when you deal with this. Because the minute you move outside your enabling legislation, I think there's a strong argument based on what I've read in relation to the EU law dealing with discovery that the exclusion from POPIA does not apply. Whatever processing you do outside your enabling legislation for the purposes relevant to the functions of a court might well be subject to POPIA, and probably will be subject to POPIA, and then you must comply with the Act. So have we got any more questions?
We've got one question that we can just attend to quickly. It refers to electronic service by a sheriff and how the POPIA Act protects the sheriff when documents are served electronically. But it's also a straightforward answer in terms of the rules allow a judge to give you a order to serve in an alternative way, or and therefore if they direct you to serve by email, place it on WhatsApp, Messenger, whatever public platforms, you are protected by the action and the mandate provided to you by the court. So it comes back to
we had a discussion, and we discussed serving by Facebook. So if, for example, you just put the whole court process up on Facebook, then that might arguably create problems, because you're going to get pushback from somebody, because even though it's a public document, you're going to create animosity and unhappiness on the part of the person. You're publishing beyond what you need to, because you could put a link to the document on Facebook and send it by private message or Facebook message, direct message, to the person on whom you're serving, and then only that person could open the link. That would be a much more prudent way of serving. So I think, if I remember correctly, when I read the rules in preparation for the seminar, it said you would serve at an email address specified by the court. So provided you're doing that, you're good to go. Of course, if you serve outside that, the question becomes, well, have you now committed a data breach, which is subject to 22 of POPIA, and do you now have to report it to the regulator and to the person whose data you've inadvertently sent to the wrong person? Okay.
I think when attending to the substituted service as directed by a judge or a magistrate, it's important to only stick to the instruction given in the court order, and not to go that little bit further to make sure, like you said, rather do it via Facebook Messenger, where it's person to person and not well, in that case again, we are also instructed to serve the divorce summons via advertisement in the newspaper. So
what's the difference?
What's the difference then? So
exactly.
That's the question.
Provided you're complying with the instructions of a court. So remember, you're the hands of the court, but the hands must be doing what the body and the brain are telling them to do, because the court is giving you orders. So stick to what you're told to do, either in your rules or in the regulations or in your enabling legislation. So we come back to this question. Are you a responsible party processing information in compliance with an obligation imposed on you by law when you serve process? I don't think you are, because I don't think vis-a-vis that process, you are certainly you are carrying out you are processing in relation to the judicial functions of a court again, but I don't think that you fall within the scope of the Act. So we don't even get into the debate of whether you're a responsible party or not. You might be a public body performing public functions in relation to national security, anti-money laundering, combating of terrorist financing, combating of proliferation financing, criminal prosecutions and enforcement. Remember, there was that other exclusion, but that's a very technical and limited one. I would be reluctant to rely on that one. Are you an operator acting on behalf of the instructing attorney? I don't think so. You're not a courier. You're not simply picking up the documents and taking them from A to B. You are performing a function for the court, instructed by the court. Now, just a reminder about some of the conditions. Remember that for processing limitations, you must process in a way that you lawfully and reasonably. Minimality, we spoke earlier about only processing what you need. Do you need consent? You don't always need consent. Where you are concluding or performing a contract with the data subject, where you are complying with a legal obligation, where you're protecting their legitimate interests, you pursuing a responsible party's legitimate interests or those of a third party to whom information is supplied, or it's necessary, the processing is necessary for a public body to perform a public law duty, that's all fine. Consent is dangerous because people can withdraw consent. So particularly in an employee situation, do you need the employee to consent to you gathering their personal information to, for example, report to SARS? Absolutely not. You are performing that as a responsible party in terms of a contract of employment. You're obliged to do it by law. Ian, another question.
Yes, we've got about 6 minutes left, so I'm going to be very quick. Mrs. Ruitt wants to know whether are you contravening the Act when you advertise your sales on your notice board, because it discloses information of the parties. But then again, that same sale notice is placed on the notice board at court. That same sale notice is placed on your notice board at the office, and the sale notice is also placed in the newspaper.
Yes.
And one thing that forms part of the execution process in terms of Rule 46 and 46A in the High Court. So I would 100%. Say you're not contravening. Then there's one more question from Mr. Naidu, who wants to know when you've attached a motor vehicle in terms of a writ, is it against the POPIA Act to confirm ownership of those vehicles if you do a windeed search or you do a traffic municipal search, if they allow you to do that? And again, you are doing it under a case number, which is used as a reference. For example, if you are doing that search in the on the Windeed platform, and therefore it's not illegal, and you're not contravening the POPIA Act because you are confirming ownership of the vehicle, not personal information of the parties.
So Ian, just to be clear, you would be confirming that who is the reflected as the registered owner of that vehicle to make sure that you've attached the vehicle of the person whose vehicle you should have attached.
Correct, ma'am.
So arguably now, the Windeed search is necessary to verify that you've attached movables belonging to the person whose movables you're supposed to be attaching.
Correct, because if you don't do that, you might find yourself selling a vehicle belonging to the bank, where the bank is the title, but the individual is only the owner.
Exactly. Okay. Okay, so where you are dealing, the rest of these slides we don't actually need to worry about. They are just reminders about the principles governing POPI and where you get information. The usual rule is you must try and get it from the data subject first, but there are a whole bunch of circumstances in which you can get it from other people and reasons why you can obtain it from other people. So this is a guide for your, what I want to get to is this: security safeguards. Have proper security measures, lock your offices, lock your filing cabinets, make sure that you password protect your devices. Don't get up and go and make a cup of tea and leave your attorney's personal details for your billing purposes on your computer screen, or bank details. Don't leave files on your desk when you leave your desk. Put the files in a drawer. Lock the drawer. Don't only use and process the information you need to be able to do what you're required to do in all respects, whether it's subject to POPI or not. Particularly if you want to rely on the Section 6 exclusion. If you want to rely on that, you cannot step one step over the line. So your bidder's record, Remember, all you can make public: name, bidding number. If you put the ID and the contact number and the address, you're in big trouble. Have a clear privacy policy. It's a function of your data assessment. Get an information officer. Everybody has to have an information officer, and you have to have a PIA manual. As I said, go and look on the information regulator's website. She's got an example of a PIA manual there. There are a whole lot of rules governing unique identifiers when they're going to be used for other reasons. That was around marketing, because people were consolidating databases and then using them to sell, to do telemarketing. Criminal reporting, credit reporting, and information of children, you need to get permission from the regulator to process that. Can't move offshore. Now, you might need to think about this where you're dealing with the digital citations. Check the rules. And that, you'd be delighted to know, is that, unless you have any more questions.
Ms. Finnigan, I've got no questions at this stage on screen. So I'm going to take this opportunity to say thank you very much. Thank you for that.
Hello, Ian. There's Michelle Jones has raised her hand.
I can't see that, unfortunately, from where I'm sitting. I don't have access to that. So I've got no idea.
Mr. Burton, she does have a question in the Q&A.
Let's have a look.
Okay. Michelle Jones made a statement. I think it's more a statement than a question. It says, ma'am, on a warrant of execution, we empty the filing cabinets and note it in our returns of service. But on a section 30, set the documents from the filing cabinets aside and inform the attorneys on our return of service of the documents, as well as give the debtors the opportunity to collect on the instruction of the attorneys. Also, I suggest we only empty them after the items are sold, as the debtors can pay and cancel the sale in execution. We can charge the attorneys on our after-sale returns for the IT service rendered, based on Magistrate Court Rules 42B, which says where no provision made for a fee, we can charge and have the taxing master adjudicate over its dispute.
I agree with all of that. Makes a lot of sense.
And then I've got one more question from Jacques van Renen. He wants to know whether your slideshow will be made available.
It will.
To everybody.
But remember, it's not legal advice. I think what we've demonstrated by virtue of all these lovely questions and the interaction is that your task is not an easy one. And you need to think about each set of circumstances take advice on each set of circumstances individually. So I hope that that has been helpful.
Yes, I've also got, there's a lot of messages coming in now saying thank you, Mr. Morrigan, thanking yourself and the SA Board for Sheriffs for facilitating this meeting, yourself. There's one question and one from Mr. Mohammed as well to say it was a great session. And then there's one more question from Mr. Tertius Roberts, who wants to know, on a telephonic call from an attorney, can you provide the instructing attorney with an email copy of the return? It says the instructing attorney.
So the person who's telling you to go and serve the process?
Correct.
Yes. I don't see any, I mean, you are obliged. The rules say that you are obliged to get a copy of the return back to him as soon as possible. And then he's obliged to go and file it in the court file, isn't he?
Correct. The only thing, only place I would be skeptical to do that is when it's the defendant's attorney who now wants a copy of the return, and the instructing attorney has not even received his return yet, as we discussed earlier.
And again, the court might be reluctant to accept the email copy as evidence, but that's an evidentiary issue rather than are you allowed to disclose the information? Is it private information which you are not allowed to disclose to anybody else? I think you can disclose it to your instructing attorney. I mean, that's your invoice. You're going to send him an invoice together with a record that you've done the job.
That's correct.
Okay.
Ms. Finnigan, allow me on behalf of the board and the training department, Mr. Nell, and the whole team at the back who who facilitated this machine to run today, and from Mr. Morgan, Advocate Morgan, myself, the training committee, my colleagues, just to say thank you. Thank you very much for doing this, and especially knowing that you did this pro bono. I really do appreciate it. You've given your
My
time.
great pleasure.
You've given a lot of information, and I really do appreciate it. I think we can all say we do appreciate it. And there's a lot of points that that have been clarified, and just to say thank you for your time. We really do
It's my great pleasure, and thanks also to probono.org, who facilitated the session and made it possible. I'm very grateful to them as well. Great.
Thank you. Great. I'm going to ask Mr. Nell to have the last word. He always seems to get that opportunity. So, Mr. Nell, I'm going to ask you if you can just end for us.
From us, it's a massive thank you to Jenny Finnigan. Very informative, most absorbing. You're a fantastic facilitator. You're a storyteller. You share so beautifully. Thank you so much, Jenny. It's really appreciated. And then, like Mr. Burton said, and to do it for us pro bono and for probono.org, thank you very much to you. We are going to be, obviously, the session has been recorded, and with your approval, we're going to put it on our website for those who have missed the session. And then Jenny has also made the session available on, well, not the slides, but in a PDF format, which it is with my team. So by all means, you can get it via. Oh no, I think Lucinda has mentioned that it will be put on the website for you to access as well. So with all of that said, thank you very much to Mr. Burton, who's also done this pro bono for the board today. He's not getting any stipend as a board member or as a co-host. Thank you very much, Mr. Burton. Thank you to the chair, our acting executive managers on Ms. Piwe Mshaba. Thank you to her for joining. All the staff at the office of the board, all the sheriffs, the deputies, the admin staff, support staff at the sheriff's office, and of course, my A team, Bernadine, Candace, and Lucinda. Without them, we would have struggled even more so. They will send out some notices. They've asked you to please go to the chat function, click on it. There is an evaluation form that they'd like you to complete and return to us. And with that, please note the next slide, or the closing slide, that we're going to put up for a session by the South African Board for Sheriffs with the CCMA and NABC, which is the National Bargaining Council. That's going to be happening in September. In fact, if I'm correct, it's the 3rd of September. Anyway, you'll see on the slide. Thank you, Mr. Burton.
Thank you, sir. Thank you, everybody. Yeah, have a good week. Thank you, Mr. Nell.
Thanks so much.
Thank you, Ms. Finnigan. Thank you very much.